Apart from the above arguments, the other most important argument, which has been raised by the learned counsel for the revisionist, is that while passing the impugned order dated 7th February 2014, the learned magistrate has ignored the command issued by this court-wide order dated 8th November 2013, which has been to the following effect. No coercive measures shall be adopted against the applicants for a period of 3 months from today or till disposal of the discharge application, whichever is earlier. If the concerned court, after hearing the counsel for the accused, feels persuaded to have the view that accused ought not to have been summoned and the charge is groundless, it shall not abstain from discharging the accused only on the ground that the material available at the time of summoning was the same which is available on record at the time of hearing of the discharge application under section 245 within bracket 2 CRPC. On the other hand, if the lower court, even after hearing the counsel for accused, holds the view that the accused have been rightly summoned and the material produced by the complainant does not indicate charges to be groundless, it shall make an order to that effect and proceed further in the matter in accordance with law, and shall also be free to adopt such measures to procure the attendance of the accused as the law permits. It is evident from the impugned order that the court below had found that there was sufficient evidence on record for framing charge, because at the stage of charge the court has to see as to whether prima facie case is made out or not on the basis of the documentary as well as oral evidence on record, and that in the present case there was sufficient evidence to frame charges against the accused revisionists. Accordingly, it directed the accused to appear before court and get themselves bailed out. Under section 245 within bracket 2, it is provided that nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case if, for reasons to be recorded by such magistrate, he considers the charge to be groundless. The aforesaid submission has some substance in a case where magistrate invokes the provision of section 205 of the code at the time of issuing process to the accused and permits the accused to appear through counsel. In other words, the power under section 205 of the code can be exercised by the magistrate even in the very initial stage of issuing process to the accused under section 204 of the code, and at that stage the magistrate may require the accused to appear in person or through counsel. If the personal attendance of the accused in the court has not been exempted by the magistrate under section 205 of the code, or he has not been permitted to appear through counsel after granting such exemption, the accused cannot deny to appear in person in the court in the garb of the format prescribed for summons.